Case of Mr. McLeod, a man who insists on representing himself while seemingly rejecting the very system he's pleading to. From missed court dates to mail returned like spam, to filing pseudo-legal nonsense, and even accusing judges of being agents of the International Monetary Fund. Yes, really, this courtroom drama feels more like an episode of a political thriller than real life. But here's the twist. The judge, while remarkably patient, is about to drop the hammer, and it's not just about contempt. It's about the limits of self-representation, the boundaries of courtroom decorum, and what happens when someone turns their back on due process. As you watch, ask yourself, what's the line between asserting your rights and outright disrespecting the court? And more importantly, how far can a judge go before a defendant loses their autonomy in court? Stick around. This one spirals fast and it ends with a serious civic lesson that every citizen should hear. Let's break it down.
Can I say a couple things first?
No.
Okay.
You can answer my questions.
Sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
You've been doing that the whole time. Under Ferretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel. However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Ferretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself...
Okay, pause here. The judge is laying out exactly why self-representation isn't a free-for-all. Yes, you do have the constitutional right to represent yourself. That's settled in Ferretta v. California, 1975. But here's the catch. That right is not absolute. When your actions start to obstruct justice, disrupt proceedings, or descend into absurdity, like sending back official mail with red marker nonsense, the court can revoke that privilege. What we're seeing here is a textbook example of someone weaponizing courtroom rights without respecting the responsibility that comes with them. Filing a letter rogatory, accusing the judge of international conspiracies, that's not legal defense. That's performance art, and the court isn't here for it. Question for you, do you think the court should allow someone to continue defending themselves even when they show blatant disregard for the process? Sound off in the comments below.
Questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments, even after being heard and ruled against. And now he has refused to participate in the court process by rejecting court mailings while purporting to represent himself. So I have now lost any confidence, Mr. McLeod, that you are able to represent yourself in this manner without disrupting the court's business or making a mockery of the court proceedings. Therefore, as this case moves forward, I am revoking your right to represent yourself.
And there it is. The moment the court says enough is enough, the judge has officially revoked Mr. McLeod's right to represent himself, citing a clear breakdown in courtroom order and respect. And honestly, it was a long time coming. You can hear the exhaustion in the judge's voice. After multiple disruptions, rejected mailings, and legal gibberish, there's no more confidence that McLeod can conduct himself appropriately. What's striking is the judge's effort to preserve McLeod's rights at every stage, even resending mail from the court personally. But rights come with rules, and when someone crosses the line into chaos, the court steps in to restore order. This isn't about silencing someone, it's about preserving the integrity of the judicial process. And honestly, the judge handled it with more patience than most of us would have.
See you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Is the court want to entertain a bond on this matter, Your Honor? To my understanding, Mr. McLeod is a local resident and he has met, with the exception of the last court date that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates.
Oh,
All. Okay. and he's employed locally, Your Honor. I think perhaps if the court would set a modest monetary bond, that would ensure future.
I will not have to get, I assure you.
Mr. Juliet?
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of
Can I speak on that?
the court rule. So he's made it clear he doesn't want to take this serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something you wanted to tell me?
I wanted to speak on that, the mailing stuff. I do that with all my junk mail, and I'm really sorry if that happened to one of your letters.
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really relying on me. This would be a really big problem if I get this revoked. Have to stay.
All right, well, Mr. McLeod, it's a shame you had to learn a civics lesson the hard way here. You are a citizen with rights and freedoms, but you also have responsibilities in a society where other citizens live alongside you. That includes obeying the laws that the people pass through their representatives. For example, the people are entitled to pass a law that says they don't want folks operating boats under the influence of alcohol. You think that law doesn't apply? It does.
That wasn't.
And when a law enforcement officer sees you violating that law, you can't resist arrest without consequence. When you are alleged to violate those laws, Mr. McLeod, there's a third.
Wow. Just listen to this moment. Mr. McLeod pleads, not for legal mercy, but for the ability to keep working, mentioning his $40,000 window job and the risk to his livelihood. But the judge cuts through the noise with something bigger, a civic lesson. This isn't just about a missed court date or a bad legal strategy. It's about understanding that citizenship comes with accountability. The judge drops truth after truth here. Rights are sacred, yes, but so are the laws that protect the public. And when you reject those laws, there are consequences. The kicker? Most people learn this lesson the easy way, but you have to learn it the hard way. That line hits hard. It's not just a sentence, it's a wake-up call. Tell us, do you think the judge was fair here, or should McLeod have been given another chance? So here's the bottom line. Mr. McLeod's courtroom saga is a case study in how not to represent yourself. From misusing sovereign citizen rhetoric to flat-out ignoring judicial mail, he managed to burn every bridge the court offered him. And still, the judge went out of his way to ensure fairness, until it became impossible. With his self-representation rights revoked, a court-appointed attorney will now steer the case. The judge has scheduled the next hearing for August 20th at 10 a.m., and by then, it's likely that the consequences for his earlier antics will be fully on display. But this case leaves us with a bigger question. How do we balance individual rights with courtroom order? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more drama, more legal insight, and more real moments that'll make your jaw drop.